insists probable cause is not the right standard, but it also doesn't defend the reasonable suspicion standard applied by the Montana Supreme Court below. Instead, Montana and the United States asked the court to adopt some other threshold that would permit officials, for the first time, to breach the sanctity of the home when they don't have permission, don't have a warrant, and don't even have facts leading to a fair probability that an emergency is actually taking place within the home. Their proposed reasonableness standard is so vague that not even the state and its amici can agree on what it means. And its open-ended balancing approach invites abuse and confusion, leaving police and first responders without the guidance they need and citizens without the security promised by the Fourth Amendment. The court should adhere to the textual and traditional standard of probable cause. I welcome the court's questions.
Do we normally use probable cause standard outside of the criminal context?
Your Honor, the court has applied probable cause in camera, for example, with respect to administrative warrants, and in other contexts as well. I would point to, for example, Wren, where the court applied it to civil vehicle infractions. And so the court has applied it in non-criminal contexts.
What is the objectively reasonable basis standard?
Your Honor, I think the objectively reasonable basis standard applied in Brigham City calls for and really contemplates, sort of lends itself to some standard of certainty. And our position is that that standard of certainty is probable cause, the traditional standard that the court has applied. Yes, Your Honor.
Well, I mean, I'm just asking what it means. Is there any difference between that and probable cause?
Your Honor, we think that the standard sounds in probable cause. The court didn't use those words in Brigham City, and it did not use those words in Fisher. But we do think that the standard echoes probable cause. I'd point, for example, to the language in Pringle, where the court said that the substance of all probable cause definitions is reasonable belief of guilt. And so while the court didn't use the word probable cause, we do think that there is an echo between the standard applied in Brigham City and the probable cause standard.